to all that welcome for this for this webinar, and I'm also I'm also just very happy to have great personalities, the speakers from Switzerland, from United Kingdom, and from Thailand. So this webinar, in fact, is very important. And when I went through the list of the countries, it came out to 18 countries are participating so far. I think it will go more than that. And there are more than 52 participants on this. So this webinar is mainly on the investment treaty arbitration. We are trying to focus on to the construction sector, because this is one of the activities which has a lot of problem. And especially after the COVID, the pandemic situation, many things are going to come up out of this. So I would like to then thank all the participants again on behalf of Thai Arbitration Institute. I am Phunso Wangdi. I'm currently working with the Institute as an advisor. And today on this investment treaty arbitration, we're trying to focus on to three main issues, major issues. First thing is to discuss possible trends in investment claims in the construction sector that may arise after COVID-19 pandemic. Second issue is to discuss how host states can prepare defenses in connection with COVID-19 measures that affects foreign investors in infrastructure or construction projects. And third is to share experience from legal experts regarding how investors can benefit from treaty protection and how investment treaty arbitration can be pursued. So from Thailand, we are expecting the Thai and the foreign construction companies in Thailand and ASEAN countries, Thai state enterprises, Thai government including Foreign Ministry, Transportation Ministry, and Railway Authority. And this is what we expect from Thailand. And apart from that, there are many participants around the globe who are currently presenting this webinar. So then, firstly, to all the participants, I would like to introduce our speakers who had taken their time. We have given them very limited time, and they have worked very hard on this because they thought that whatever they do will be a big contribution to the world. So they worked hard within the very short span of time, and we are organizing this in collaboration with Tiliki and Jiban. So we have requested them, and they are all here. So firstly, we have on my left hand side, Chinna Irwin. She is counsel at Lalai, based in Switzerland. Then on my left hand side, I have Daniel Granita, who is a partner at Peter and Kim, based in Switzerland. Then below me, we have Jonathan Limp, who is a counsel at Wilmer Hill, United Kingdom. And then we have Nopromat Thamame Decho, who is a counsel at Tiliki and Jiban, Thailand. So my job is to be a moderator. So basically, I'll be then managing time, then also then seeing the questions and all. So just to give an overall brief on this matter from my side. Investment arbitration procedure, in fact, is the effective means of settling disputes between the foreign investor and host state, through which a foreign investor can sue the host state for breach of the conditions provided in the bilateral investment treaty. Investors are given access to an independent and qualified arbitrators who will resolve the dispute and render enforceable awards through different protections under international treaties, which means that foreign investors could bypass national jurisdictions which could be perceived to be biased or lack independence. The substantive protections provided in foreign investors will depend on the international investment agreements upon which the claims are brought, and such protections are different from the protections afforded by domestic laws of the host state. So broadly, there are around six common protections which are afforded to the foreign investors. First is protection from expropriation without compensation, whereby acquisition of the investor's property by the host states for public interest should be done through due process, followed by payment of reasonable compensation. The second is on fair and equitable treatment by not denying justice in civil, criminal, and administrative proceedings by the host state. Third is national treatment, where there must be equal treatment between the entities of the host state and investors. And fourth is the most favored nation treatment, where there must be equal treatment between member states, especially WTO. Then fifth is free transfer of investment in returns by allowing investors to transfer funds in and out of the host state. And sixth one is full protection and security to provide physical protection to the investors' properties during the civil rights in the host state. So these are broad overall issue in nutshell, which I want to share on this issue. And we have 1.5 hours to go. So it should be end by 4:30. And each speakers will do the presentation for 15 minutes. We have limited the time so that we'll have more time to do the discussions at the very end. Then after the presentations are over by the four speakers, then we will start the question answer. So to do the honor, I would like to firstly invite Gina to do our presentation. But before that, I want to briefly introduce onto her professional experiences. So here, first, Gina will be doing the presentation on general introduction to investment claims in the construction sector. For example, typical investors, typical investment and common claims. So Gina even is an international arbitration lawyer practicing with Limp in Geneva, Switzerland. Gina represents clients in both commercial and investment treaty arbitrations with a focus on the complex dispute involving major construction projects, consortium and joint venture agreements, and issues arising in the transportation sectors. She has acted as counsel on various arbitration proceedings under various procedural rules, including ICC rules, LCI rules, Swiss rules, UNCITRAL rules, and ICSID convention. She is the deputy editor of Construction Law International, the quarterly magazine of International Bar Association's International Construction Projects Committee. She is also a member of several professional associations, including the Society of Construction Law and Swiss Arbitration Association. Gina has been ranked for multiple years by Who is Who Legal as a future leader in construction. Prior to joining Limp in 2015, Gina practiced international arbitration at international law firm in Geneva from 2011 to 14. Gina holds Juris Doctor from University of Virginia School of Law in 2010, where she participated in dual degree program with the Institut d'Études Politiques de Paris, through which she also earned a master in global business law. So this is in very brief. I'm trying to introduce her CV. So it's very lengthy, it's very big, but this is in a nutshell how I want to introduce her. So with this, I would like to now invite Gina to do the presentation for the audience. Thank you so much.
Thank you very much for that introduction. Good morning or good afternoon, depending on where you are. So today I'd like to give a very brief introduction in the next 15 minutes to investment treaty arbitration cases in the construction sector, including a look at the typical investors, the typical investments, and the claims that are common in such proceedings. This may already be familiar to some of you, but hopefully it will be a good refresher to start our discussion today. And we'll be able to delve into the details also with input from my colleagues during the question and answer session at the end. So participating in construction projects abroad may expose contractors to additional risks beyond those inherent to any domestic construction project. For example, the political situation or changes to legislation could adversely affect the project. But this additional risk is in some cases balanced by additional protections, which may be available to the contractor through protections offered to foreign investors in the country where the construction project is located. There are a growing number of investment arbitrations in the construction sector, including arbitrations administered by ICSID. According to ICSID's published statistics, 9% of the cases registered between 1996 and 2021 concerned the construction sector. And of the new cases registered last year in 2020, 17% concerned the construction sector. There seem to be several factors driving the increase in investor state arbitration in the realm of construction. One is simply the very high number of international construction projects. Also, the use of certain project structures, such as the build, own, operate structure or public-private partnerships have contributed to this rise. And lastly, just simply a better awareness of the option of pursuing claims through investment treaty arbitration. So investment treaty arbitration will provide different or sometimes additional remedies as compared to the construction contract for a contractor who has suffered loss on a project. But the requirements for the investment arbitration are also quite different than a commercial arbitration. So while a commercial arbitration is brought on the basis of the arbitration agreement contained in the construction contract, investor state arbitration is brought on the basis of the host state's agreement through a multilateral or bilateral investment treaty to have certain disputes determined in international arbitration. So as we heard in the introduction, the basic requirements if you want to bring a investment treaty arbitration are first a investor protection regime, namely the bilateral investment treaty or the BIT. Next, a claimant who meets the definition of a qualifying investor, an investment which meets the definition of a qualifying investment, and violations of the protections afforded to the investor under the protection regime. So let's start with looking at the investor. So the investor can be an individual or a corporation. To determine whether a person or entity qualifies as an investor, one should look both at the definition under Article 25 of the ICSID Convention, assuming that the ICSID Convention is applicable, and also the definition in the BIT itself. The key criterion for determining whether an entity or a person is a qualified investor is the nationality or citizenship. So for natural persons, an investment treaty normally requires that the investor has the nationality of the other contracting party to the treaty. Some treaties also require that the investor be resident in the other contracting state. For legal persons, nationality is determined on the basis of the place of incorporation, the place from where the entity is controlled, or the place where the seat of management is located. Some BITs have further requirements. For example, a BIT may require that the investor has a further connection to the contracting state, such as carrying out substantial economic activities in that territory. Other BITs specifically exclude companies owned by nationals of the host state, regardless of where they are incorporated or carry out their business activity. Those types of clauses are sometimes called denial of benefits clauses, and they're meant to discourage treaty shopping, where investors use shell companies purely to establish jurisdiction under a favorable investment treaty. So in international construction projects, we see quite a lot of consortia and unincorporated joint ventures. But in the investment treaty context, normally only the individual entities can be claimants, provided that they meet the requisite criteria. So that's the investor. Then if we look at the investment, unlike an investor, the ICSID convention doesn't define an investment, but this is very often defined in the BIT itself. The standard that tribunals will generally more or less apply to determine if something qualifies as an investment comes from the well-known Cellini versus Morocco Test case, and you've probably all heard of the Cellini test. So the essential elements of that test are a substantial commitment. Normally, that's a significant contribution of money or other assets, an assumption of risk, an appropriate or reasonable duration, and a contribution to the host state's economy. Although this last element, the contribution to a host state's economy, is more controversial and is not always applied. So if we're talking about the construction sector specifically, the investment could be, for example, the rights acquired under the construction contract or a concession contract for real estate development, for example, and or the plant, equipment, and materials that the contractor imports to carry out the construction works, or bank guarantees provided for the purpose of the works. There's also almost always a requirement that the investment is made in compliance with the laws of the host state. And this becomes an issue sometimes in the construction sector because there might be allegations of corruption in connection with the procurement of a construction contract or a concession contract. So next, let's talk about what kind of claims can be brought if you have a qualifying investor and an investment. In commercial arbitration under construction contracts, the claims are normally for breach of contract or wrongful termination, or for delay, disruption, additional costs that the contractor considers are compensable under the terms of the contract. But claims in investment arbitration have to be for violations of the specific protections offered under the investor protection regime. There are differences between BITs, so parties should look at this closely, but as we heard in the introduction, the protections typically offered include the right to fair and equitable treatment by the host state, the right to full protection and security for the investment, protection from unlawful expropriation of the investment, protection from discrimination, and sometimes also an assurance of the observation of the state's obligations. So let's look at what that would mean in the context of construction projects. So if we take first the fair and equitable treatment or FET provision, so there are two aspects of the FET requirement. First is protection from denial of justice, meaning procedural fairness and transparency. Second is freedom from coercion or harassment and protection of the investor's legitimate expectations in a stable and predictable economic and legislative environment. So conduct which might violate this provision could include, for example, unexpectedly changing legislation in a manner that's detrimental to the construction project, revocation or denial of licenses or permits for arbitrary reasons or in a manner inconsistent with the contractor's legitimate expectations based on either assurances or prior experience in the host state, or unfair or improper financial penalties. So to give you some examples, in the case of MTD versus Chile, the Chilean Foreign Investment Commission actually approved a real estate project, although it was against the government policy. So then the investors spent time and money developing the project and were subsequently refused a construction permit. And in those circumstances, the tribunal found that the commission's approval of the project was a violation of the FET provision. To give you another example, in the case of Metaclad v. Mexico, a US investor was denied a construction permit for a landfill, despite the fact that they had been specifically assured by the government that they would receive that permit. And that was also considered to be a breach of the FET provision. So next, the full protection and security. So the host state has to exercise due diligence and reasonable measures to protect the foreign investment. This means physical protection as well as legal protection. So I've listed on the slide a couple of cases where the tribunal found that an FPS provision had been breached, and these involve damage by soldiers or state security forces, which would be rather very clear-cut examples of violation of a FPS provision. So the one that probably comes up the most in the context of construction disputes is expropriation. So it's accepted that a state has a sovereign right to expropriate property for economic, political, social, or other reasons if adequate and prompt compensation is provided. But BITs protect foreign investors from unlawful expropriation. So this can be full or partial. It can be direct, meaning, for example, nationalization, or indirect, where actions result in the investment becoming worthless, even if the investor retains ownership and physical possession. So, for example, seizure of a contractor's equipment or materials would be direct expropriation, or seizure of the project itself. Whereas the host state passing legislation that nullifies or modifies the underlying contract would be indirect expropriation. This was the case in ADC versus Hungary, where the government made changes to legislation concerning the Budapest airport. And as a result, the investor ADC's contract to renovate, and construct, and operate terminals was voided. Protection from discrimination. So there are two types. First, claims concerning national treatment, which is the right to receive the same treatment as domestic investors. So for example, if a state employer was withholding payment from a foreign contractor, whereas local contractors were continuing to be paid, that would be a breach. The other part is claims concerning most favored nation treatment, which is the right to receive the same treatment as foreign investors from other states where the BIT may provide more favorable protections. So for example, in MTD versus Chile, the investor was able to invoke more favorable provisions in other BITs that had to do with the obligation of the state to grant permits. Which brings us to the umbrella clause. And this one is a bit trickier and more controversial, but some BITs have what is known as an umbrella clause, which is essentially a commitment by the host state to comply with its obligations entered into with respect to foreign investments. So where a construction contract is made directly with the state or a state entity, a claim for failing to perform obligations as employers could potentially be both a breach of contract and a breach of the BIT. But it's still a matter of debate whether purely contractual claims can be brought as treaty breaches. So for example, I have on this slide two cases that involved the same claimant where the tribunals reached differing conclusions on this. For any of these actions that we've discussed, there's the requirement of state conduct, which I probably should have said at the beginning because this is very important. And that means the conduct at issue has to be either directly by the state or attributable to the state as a matter of international law. And this question of attribution is rather complex, and I don't think we'll have time to go into the details of that today, but it's something that potential claimants and also states defending against claims should examine quite carefully. So why would a contractor want to pursue investment arbitration? Well, sometimes treaty arbitration is the only option for the contractor to pursue its losses. If the state is not the contractual counterparty, then interference with the contractor's rights may not be claimable under the contract. But in some cases, the state conducted issue could give rise to both contract claims or investment treaty claims. But in those cases, a contractor might still consider treaty arbitration as the best option. For example, if the contract would require that the dispute be referred to local courts, which could, depending on the jurisdiction, be unpredictable or opaque. Also, the construction contract will generally limit the types of losses that are recoverable and also impose a cap on damages, which would not necessarily be the case in treaty arbitration. Also, investment treaty arbitration tends to be much more public than commercial arbitration, which may give the claimant contractor a certain amount of leverage in some circumstances. So that was just a very quick, very brief introduction, and I'll now turn things over to my colleague, who I think are going to delve into some more detailed discussion.
Okay, thank you so much. Thank you so much, China. It's very good that you have broadly covered on the status of the construction case, which has increased from 9% to 17% by 2020. Means now the activities on the constructions are increasing. So this is awareness for every one of us. Then we have also touched on the basic requirements of investment treaty claims relating to the definition of the investor, definition of the investment. I think this is very important because some of the participants may not know about this issue. So I think it's good that you touch on this. And also you also covered on the investors protection relating to right to fair and equitable treatment, right to full protection and security, and the protection from unlawful expropriation of the investment. And it's good that you also cited some of the important cases, examples of arbitrary action by the host state through these cases. So I think this has really given insight to all the participants on this issue on the general note. And if the participants have any questions, you can ask questions or comment at the end where we have allocated the time. We have 20 minutes. So now, second, we have Daniel Granada, who is based in Switzerland. He'll be talking on the investment claims likely to arise in the light of COVID-19 measures, including a discussion on what the typical defenses will be. So this will be very good for both for the government and also the investor. So before Daniel will present the paper, I would like to briefly introduce Daniel, his professional experiences. So Daniel Granada is an English qualified barrister and partner of Peter and Kim, a specialist dispute resolution practice in Geneva, Switzerland. As a counsel, Daniel Granada advises and represents parties to arbitration. He also accepts arbitrator appointments. He is trained at London Commercial Bar and was an associate in the arbitration group of Wilmer Hill in London for over 3 years before moving to Switzerland in 2011. He routinely works with lawyers from different common and civil law backgrounds, and many of his cases involve the application of foreign law. In this, he benefits from being a native speaker of both English and German. Much of his practice involves complex factual and expert evidence, in particular damages calculation. He has particular expertise in corporate and construction disputes as well as disputes arising in the energy sector, including price reviews under long-term supply contracts. He has also assisted clients in settlement negotiations and has a particular interest in ADR, including expert determination and mediation. Daniel Granada is ranked as both a future leader in arbitration and a leading construction lawyer in Switzerland in Who is Who Legal in 2018, 19, 20, and 21. He was educated at University of Oxford and City University, London. So this is a brief introduction in nutshell about Daniel Granada. If I just spell out everything, it will take hours and hours. So to cut down the time, I just briefly introduced him. So I would like to now request Daniel Granada to do the presentation on the subject matter. Thank you.
Well, thank you very much for your kind introduction, and my thanks to the Thai Arbitration Institute for this invitation. Travel is rather difficult at the moment, as you will all have experienced, and especially as a partner of a firm that also has offices in Seoul and Singapore, it's wonderful to be able to get away from Geneva and spend a couple of hours in Bangkok. I have a presentation which I shall now try to share with you. There we go. And I have the difficult task compared with China of setting out some of the typical defenses and the position of the state in defending investor-state claims. International investment is the lifeblood of our global economy, and construction and infrastructure projects confer many benefits to users all over the world. What would the world be without new airports and motorways? Protection of those investments is very important. And so if you take the position of the state that is defending itself, you are perhaps, in the eyes of the global economy, in a slightly difficult position. Let me begin with a couple of very general reflections before we look at some of the more technical legal defenses. The first point is that the COVID-19 crisis of the past year and a half has caused many people and many companies, and indeed many states, to suffer great hardship and incur great losses. I particularly feel for the young people whose education and professional prospects have been disrupted by lockdowns, by illness, and sometimes by death. Many of those people will not be receiving very much or any compensation from their governments or from anybody else. Second point, governments have had to take very difficult decisions, and it is very unclear which of those decisions will turn out in the long term to be absolutely right and sensible. It's not easy managing a global crisis. I say that to set also because I think that we as arbitration practitioners and users must be aware of the fact that ISDS has faced a degree of controversy in recent years. I'm not saying for one moment that all the criticisms are justified, but it's worth remembering that there are powerful voices in the political establishment and the wider global community who ask themselves, why should a company receive better compensation just because it's foreign than a domestic company could receive? There are others who feel that the awards sometimes paid out, in exceptional cases, I stress, are excessive relative to the gross domestic product and the industrial power of the country against which the award is made. Remember that I read a statistic that it would cost $39 billion to vaccinate the entire world against COVID, which would probably be the strongest step to controlling the disease globally in the long term. The UCOS tribunal awarded $50 billion against the Russian state. Now, let us progress. There we go. I said earlier that states had been driven to take some quite exceptional measures in managing the crisis. And here are steps, some examples of recent steps. Mexico's pandemic response, for example, has resulted in heavy cuts in its renewable energy sector. Remember, there's probably a foreign investor there. Peru has suspended toll fee payments, and in March 2020, the Spanish government took steps to take control over private hospitals to manage capacity. In El Salvador, there were steps to waive water bills for users for a matter of months. And here, remember that water is essential for the most basic form of protection against illness, which is good personal hygiene. If you don't have water, you can't even wash your hands, which is which we think of as the simplest and most basic means of protection. And similarly, Argentina and Bolivia took steps to suspend water service disconnections. Now, we can argue whether those steps were in every case useful and justified, but we can also assume, and early indications suggest this, that there will be foreign investors whose investments will be affected by it. If I were a state, or I were representing a state, I would be fighting a battle not only before arbitral tribunals, but also in the court of public opinion to say, I am not the respondent of last resort. And if I'm fighting to save my children from a burning house, I may not remember to close the windows, which is what the landlord would like. China will tell us that investors have very different arguments and very powerful arguments at their disposal. China has already addressed at some length the standards of investment protection that may have been violated. I cannot, in the time available, go over those points again, and I certainly couldn't do a better job than China of providing a brief overview. But I will make a couple of points of a more general nature when we look at questions of expropriation, fair and equal treatment, full protection, and most favorable nation clauses, and umbrella clauses and the like. Point one is that although COVID-19 arbitrations is going to be a buzzword in the conference circuit and in the publicity materials of law firms for years ahead, we should also remember that not every case and not every event every dispute that is linked in some way in the mind or in the of lawyers or users is actually directly related to it. For example, a state may pursue a policy of expropriation without compensation, irrespective of whether there is COVID, but that might just be a convenient backdrop to do it. If I'm arguing from a state's point of view, I could turn the argument around and also say that the state is simply trying to use, that the investor is trying to use emergency measures as some sort of excuse to disguise failings in its own investment, its own management of the investment, and claim compensation from me as the state, blaming, let's say, a drastic emergency legislation. I have a good story about this that relates directly to the construction sector, but involves a rather different part of the world. I remember reading an award nearly 15 years ago, when I was at the beginning of my legal career, by a very experienced international construction arbitrator. It concerned a pretty typical construction dispute involving a project in Ukraine. The contractor had been a bit slow, the employer had been a bit impatient, the employer hadn't wanted to pay the contractor, and the contractor had probably done a few things to annoy the employer. It's a typical dispute. In the award, the arbitrator analyzed a series of supposed delays and disruption events. The arbitrator went through all the usual problems, site access and the like, and then hit upon the assertion, Orange Revolution, a major political event in Ukraine at the end of 2005, beginning of 2006. This, he said, is not a delaying event. You can't just point to the politics of the day and derive an entitlement from it. And all investors are going to have to prove that their claims fall precisely in the categories that China has outlined. And if they make use of buzzwords like COVID emergency legislation, you as the state, or I as the state's counsel perhaps, will challenge them to prove every part of the case. I shan't go through this because, as I say, it overlaps with China's outline and probably isn't as good. But let's look a little bit more at state defenses and state exceptions that the state can argue. After all, a state needs and has some legally recognized powers to protect itself and to protect its citizens in difficult times, even sometimes at the expense of protecting foreign investors. First of all, look very closely at the investment treaty to see if it has any relevant carve-outs to protect the government in cases of political unrest. Then you may wish to ask yourself whether the COVID measures have been essential for security reasons and the maintenance of protection of public health or human life. And here I have to make another point as to how we as lawyers need to present our cases. COVID's a buzzword, but it isn't actually one event that happened in one place at one time. It's not like, let's say, a storm that suddenly destroys a building site out of the blue. There are many events, some of those taking place on an international level and others on a domestic level. There is a whole chain of events of different government policies, different measures that are introduced. Now, let's look a little bit more seriously. Here we have a force majeure, and I take here the ILC, International Law Commission document on illegal acts by states as a point of reference. The first problem, force majeure the force majeure would allow a party that has an obligation to do something to be excused of its failure to perform that action because of unforeseeable events outside the control of the party that made it impossible for it to perform that. And the argument has been used here in investor-state intervention in a case involving Venezuela. Most of these cases seem to involve Venezuela in some form. I would make one point on force majeure, and this goes for commercial disputes as it does for investor-state arbitration, and that is that I think on its face that to say the COVID crisis was something unforeseeable and totally unforeseen is perhaps a little bit far-fetched. We saw the SARS crisis, we've seen the Ebola crisis, and most governments that act responsibly have had contingency plans for the outbreak of covering the outbreak of a sudden epidemic, which at least shows that some danger was foreseen. But obviously, as we lawyers like to say, it all depends on the individual case and the facts. We note here that it's unusual for states to invoke a force majeure defense. It's more of a more of a private law defense in commercial, contractual disputes, and we'll also have the difficulty of the state having to establish that performing of an obligation became materially impossible, very high standard. It's never easy to argue force majeure. Another argument which might be available to the state is to say necessity. It may only be argued in very narrow circumstances. An essential interest against a grave and imminent peril does not impair an essential interest of the state towards obligations which exist. And in any case, the international obligation question must exclude, and the state must not have contributed itself to the situation or necessity. I highlight that last point because it is very difficult when you as a state are arguing, are presenting are managing a crisis and undertaking a great many steps in relation to the crisis, not to reach a point at some point in your crisis management where you have contributed to the situation of necessity. Again, there are examples here from in a case involving Argentina, where Argentina argued that it was necessary to take certain steps in a response to the financial crisis in the early 2000s to manage formed unrest. The next argument is distress that might be available. This is a difficult perhaps a difficult argument because it would excuse a party's action which might otherwise be wrong in a situation where it has a special obligation towards someone or some group of people. Perhaps difficult to talk about a state in relation to the whole population. And then we have briefly the police powers doctrine, the doctrine that if a party has some power to protect the welfare of its citizens. I think this probably will be a significant line of argument in investor state cases in the years to come. And I cite here the example of the Philip Morris international claim against Uruguay, which concerned Uruguay's decision in relation to the packaging of cigarettes, which obviously made business for Philip Morris rather less good, but it was also intended to do so, but it was defensible on the grounds of public health. I also throw up a couple of points so we see these issues in a wider context, also of how, not only of how parties will argue particular cases substantively, but also to see how they will approach COVID cases. If you are a respondent and the state is the respondent, you may try to take advantage of the situation to request a suspension of the proceedings, to seek substantial extensions to the procedural timetable, or to request a stay of enforcement. In other words, tactically and procedurally, there may be a state may also want to use the crisis in order to prolong or complicate the proceedings to avert an adverse finding by the arbitral award. And that, I hope, was about 15 minutes. So thank you very much.
Okay, yeah, thank you so much, Daniel, for this very comprehensive presentation, which really helped both the investors and also the host state. You have broadly covered on the possible violation of the standards of protection under the investment treaty, such as expropriation, fair and equitable treatment, full protection and security, most favored nation treatment clause, and national treatment. We have also broadly covered on the state defenses and exceptions. These are very important, whereby COVID-19 might be adopted for essential security reasons to maintain order or to protect human life and health. And you have also explained detailed on the defense under Article 22 on the force majeure, Article 24 on the distress, and Article 25 on the necessity under ILC. So then at last you have also broadly covered on the police force doctrine, where the state can use on this if required. So I think this is very good. And later on, if people have any questions related on this, they can ask question. And I hope that this has benefited all the participants. And I would like to again thank you for this very comprehensive presentation. Thank you so much, Daniel. Then the third speaker now we have is Jonathan Limp, counsel at Wilmer Hill, United Kingdom. Jonathan will do a presentation on case studies of recent cases, including those involving Thailand. So before the presentation, I would like to briefly introduce Jonathan. Jonathan Lim is a counsel at Wilmer Hill in London, focusing on complex international disputes. He has represented government and corporations in commercial and investment arbitrations under all major arbitration rules cited across Africa, Asia, Europe, and South America, and as well as WTO disputes. He has also advised governments in Africa and Asia on a range of public international issues and the drafting of arbitration legislation. In addition to his practice as counsel, Jonathan has a developing practice as an arbitrator with appointments as sole and party appointed arbitrator in proceedings seated in Europe and Asia. Jonathan also co-teaches a course on international arbitration at National University of Singapore each January. He is listed in Who is Who Legal in 2018 to 18, 19, 20, and 21 as a future leader in international arbitration, and has been described by his clients and peers as very smart, all-round lawyer with a strong work ethic and a sure bet as a future global leader. So this is a brief description about Jonathan. Otherwise, I went through his CV, and it's amazing. It's quite bulky. It'll take hours to introduce him. But in a nutshell, this is what Jonathan has been doing so far. So now with this, I would like to request Jonathan to do the presentation on the subject matter. Thank you.
Thank you very much, Mr. Wang Di. I'm trying to get some slides on the screen. Can I confirm that you can see them? No, you can't?
No, it hasn't come.
No problem. Let me just try that again. How's this?
Oh yeah, yes. It has come now. Good.
Perfect. But well, let me first say what a great pleasure it is to be here with you today. Unfortunately, as Daniel says, I would have much preferred if we were all in Bangkok. But I'm very glad to be here with you today, even online. And to be with our excellent moderator, Mr. Wang Di, as well as my distinguished fellow speakers, Ms. Irwin and Mr. Granada. My sincere thanks also to the Thai Court of Justice and the Thai Arbitration Institute for inviting us to join you today. I've been asked to address you on recent case studies involving Thailand. The slide on the screen provides a little roadmap of what I propose to cover. I will start with an overview of Thailand's investment treaties, followed by an overview of cases involving Thailand and Thai investors. And after that, I will turn to one particular investment claim against Thailand involving a dispute in the construction sector. And this is not the only one which has resulted in an award, but also a slew of court decisions that will provide rich material as a case study for discussion. So I turn now to Thailand's investment treaties. At the date of last checking, Thailand is a party to 47 investment agreements in force, including 36 BITs, 4 bilateral FTAs, and 7 plurilateral agreements, which mostly negotiated under the auspices of the Association of Southeast Asian Nations, ASEAN. I want to focus on investor-state dispute settlement provisions in these treaties, Out of these 49 investment agreements, 39 provide for investor-state dispute settlement, ISDS. But that doesn't tell the full picture. Although Thailand was an early mover in terms of signing BITs, it signed its first BIT with Germany in 1961. In terms of ISDS, Thailand went through 3 phases. Historically, before 1989, Thailand's BITs did not include ISDS provisions at all, so they would only include provisions on state-to-state arbitration. That's in the Germany-Thailand BIT signed in 1961, for example, but also applies to many BITs with major trading nations, including the UK, China, Netherlands, and the US Treaty of Amity, signed in 1966. In 1989, Thailand began to agree to ISDS, but limited its consent in a way that practically means that ISDS is not available under these second group of treaties. Specifically, between 1989, Thailand concluded 9 BITs that allowed ISDS, but only if both states were party to the Exit Convention. So let me give you an example of what that looks like. So that's found in the BITs listed on the screen. For example, take the first one, Korea-Thailand in 1989. It would have a provision like this, Article 11 of the Korea-Thailand BIT. So it provides for investor-state arbitration only in case both contracting parties are contracting states to the Exit Convention. And as a point of interest, Thailand did sign the Exit Convention in 1985, but it never ratified it. So in effect, under these 9 treaties, there are no provisions for ISDS that are applicable. Obviously, if Thailand ever did ratify the Exit Convention, that would then activate the ISDS clause under these treaties. There is a third category of treaties, just going back to slide 3, from 1993, whereby Thailand started to include the option of ad hoc arbitration under the UNCITRAL rules. Started to do so with the Romania-Thailand BIT. So if you look at slide 8, for example, Article 8 provides for a list of options for an investor. It could bring a dispute before competent courts of the host state. For an investment in Thailand, that would be Thai courts. It could bring a dispute before the Exit Convention in case both contracting parties are contracting states. So again, with the same qualifier. So that doesn't apply now because Thailand hasn't ratified the Exit Convention. But there is now a third option. If you look at Article 8(2)(c), it provides for arbitration before an ad hoc arbitral tribunal. In practice, most ad hoc arbitration, investor-state arbitration proceeds under the UNCITRAL rules. And just briefly on Thailand's other investment treaties, and you'll see a conclusion I'll draw from this and why it's relevant to the case study. Thailand also has bilateral FTAs with ISDS. It's listed on the slide, FTAs with Australia, New Zealand, Japan, Chile. Thailand's also a party of a number of plurilateral investment agreements through ASEAN, also listed on the slide. These have slightly different ISDS provisions from the BITs. But if you look at the slide 10 and the graph contained there, that provides a sort of distillation of Thailand's investment treaties over the years. You'll see that most treaties involving the option for ISDS was signed in the 1990s and 2000s. A few reflections from that quick tour. The first is the observation that Thailand's non-ratification of the Exit Convention means that investment arbitration under Thailand's treaties is only mostly, and in fact in all cases, ad hoc arbitration under the UNCITRAL rules. Arbitration is also possible under the Exit Additional Facilities rules, but the consequence of that is that for these investment arbitrations, there will be a seat of arbitration where the award can be challenged. And if an award is rendered in the investment treaty arbitration, enforcement will be sought and resisted under the New York Convention. That leads to some interesting reflections as we talk about the Walter Bao case shortly. The second observation is you can see Thailand has signed very few BITs since 2010. In fact, it's only signed one BIT in 2015. And since then, it hasn't signed any. There appears to have been a shift, if you look at its negotiating pattern, in the time towards prioritizing investment chapters as part of broader trade agreements, both bilaterally and part of ASEAN. And there are, as many of you are aware, ongoing discussions about the CPTPP as well as suspended discussions with the EU. The second development that is relevant to this is that Thailand appears to be revising its model BIT. I think I've seen reports announcing that it would be published end of 2020, early 2021. I haven't seen that published, but perhaps others on the call may be aware of it. I'd be happy to have a discussion about that. So turning now to cases under those treaties, there are only 3 known cases that I could find involving Thailand as respondent. There's the Walter Bao case, which I'll talk about shortly. Then there's the Kingsgate versus Kingdom of Thailand case. It's not strictly speaking a construction dispute. It's a dispute arising out of the first and largest modern gold mine, the Chatri gold mine in Thailand. I understand it's just north of Bangkok, which Kingsgate opened in 2001 and expected to operate until 2028. But in 2016, due to public concerns about health and safety impacts of the gold mining industry, I understand in particular some concerns to the use of cyanide and its impact on water supplies in surrounding local communities. The Thai government announced that all gold mining in Thailand would cease by the end of 2016. Thereafter, I think Kingsgate and Thailand were in discussions about renewals of pre-existing licenses and how that would be impacted by that new order. But suffice to say that those negotiations did not go in Kingsgate's favor, and they filed for arbitration, claiming that the Thai government's actions constituted expropriation. The case appears to be still ongoing, with a tribunal constituted in March 2018 to hear the claims. There are also parallel proceedings in Australian courts between Kingsgate and its insurer. And it was reported in March 2019 that Kingsgate reached a settlement with its insurers for a partial amount of the loss in relation to the same project. So that will raise interesting questions about double recovery and the interaction between the court proceedings and the ongoing treaty proceedings. As a brief footnote, there's a third known case filed by a Malaysian investor, Regina Wenli Ng, who reportedly filed a notice of dispute in relation again to a gold mine in the Loei province. Ms. Ng was a minority shareholder in a Thai company that operated the mine, and not much is known about this claim except that it is sort of the notice of dispute has been made public. It's not clear whether the claim is still ongoing. In fact, in August 2015, the local company, Tonka Harbour, entered into a bankruptcy process. There are other commercial cases involving Thailand, which I will not touch on for this call, but happy to take questions or have a conversation about them. There are also cases where Thailand, not surprisingly as an increasing net exporter of investments, where Thai investors have initiated claims against other respondent states. Those cases are mostly still ongoing, and the names are on the slide. In the interest of time, I'll just move on to the third section, which is the case study of the case of Walter Bao and Thailand. I suspect many of you will be familiar with the facts of this case, so I'm going to be brief, but the claimant is a German company, which had a minority 9.87% stake in the Don Mueang Tollway DMT consortium, which contracted with Thailand to finance, build, and operate, and eventually transfer a toll highway, the Don Mueang Tollway. You can see a picture of it on the slide. Essentially, DMT bore the entire capital cost of designing and constructing the tollway, plus the operating cost of running and maintaining it for 25 years, after which the consortium was to return the tollway to Thailand at no cost. The construction of the tollway and its extension was duly performed over a 5-year period, and as I understand it, the tollway is fully functional and was fully functional at the time of the arbitration. Waterbell fell into insolvency in April 2005 and initiated arbitration proceedings against Thailand, alleging that certain actions, in particular a refusal to raise the toll despite multiple requests, amounted to creeping expropriation, as well as a breach of the fair and equitable standard of the 2002 German-Thailand BIT. I mean, that's an interesting point to note, pausing there, because I mentioned earlier that one of the first BITs that Thailand signed was in 1961 with Germany. And so in this case, the fact that there were two successive BITs, the 2002 Germany-Thailand BIT, terminating the earlier 1961 treaty, gave rise to some interesting jurisdictional issues that I will address shortly. So the proceedings were bifurcated. So there was an initial jurisdictional phase leading up to a partial award on jurisdiction issued in October 2007. And then there were subsequent proceedings on the merits, which resulted in a final award dated 1st July 2009. So let me speak briefly to the issues that came up in the jurisdictional phase. First question is whether the claimant had an approved investment for the purposes of Article 8 of the 2002 treaty. Article 8 provided that the treaty shall also apply to approved investments made prior to its entry into force by investors. Here, the question was whether, in addition to having obtained specific approvals from various governmental departments and agencies to build the tollway, as well as approvals of the concession contract between the construction company and the Thai government, whether the claimant needed to obtain a separate certificate of admission of investment for the purposes of BIT protection, which was obviously Thailand's argument. The tribunal heard evidence from both the claimant's expert, Professor Sompong, and the respondent's expert, Dr. Plasai, who was, interestingly, then also the Director General of the Department of International Economic Affairs at the Thai government's Ministry of Foreign Affairs. The claimant's expert took the position that the investment had already been approved to the extent it was required. Alternatively, Thailand was stopped from deviating from the approvals and the assurances given by government agencies to the claimant from asserting that the investment was not approved. The respondent relied on a protocol to the 1961 treaty, which referred to a certificate of admission by appropriate authorities in accordance with Thailand's legislative and administrative practices. Based on that, the respondent's expert opined that there was a two-step approach before an investment would qualify for protection under the treaty. First, there would have to be an approved acquisition of a concession or concession rights. Second, there would have to be specific approval of the investment for the purposes of the BIT, and that approval would have to be granted by the Ministry of Foreign Affairs. This issue is not that uncommon. It comes up quite frequently in cases involving BITs with ASEAN, Southeast Asian parties, and the approval requirements also found in many of the ASEAN plurilateral agreements. And quite typical of decisions in this space, the tribunal took a very broad view of the approval requirement in Article 8, noting, of course, the object and purpose of the treaty, which was to promote investment, and as well as the absence of any legislation in Thailand that required the investment to be specifically approved by the MFA. So the tribunal took the view that the approvals that the claimant had already received from the Board of Investments was sufficient to qualify the investment as approved investment for the purposes of the BIT. The tribunal also took note that if the Thai government wanted to draw a distinction between approval by the Board of Investment and approval for the purposes of the BIT, it could have done so as a matter of its internal law, for example, through legislation, but there was no evidence of this having been done. The respondent also raised other arguments that approval only extended to building of the highway, not to the investment made by the claimant, and that the 2002 treaty required a fresh approval. So it's not enough to be approved under the 1961 treaty. You've got to be approved separately when the 2002 treaty came into force. In short, the tribunal rejected these arguments, taking the position that the 2002 treaty was not intended to take away rights already acquired and accrued by investors. The tribunal also noted quite interestingly that it was attracted by the claimant's argument that even if there was this separate requirement for a certificate of approval, the respondent would be stopped from objecting to jurisdiction by the principle of estoppel, but the tribunal declined to decide on this point, noting that it would need further evidence of detriment. So that's the issue of the approval of investment. The other jurisdictional issue was about the acquisition of the shares, because the company originally possessing the shares was a company called Duidag, which I'm probably butchering it, which was later merged by absorption into the claimant under the German Transformation Act. The tribunal had to decide whether the claimant was an investor for the purposes of the 2002 treaty, despite the fact that the initial investment was made by a different German party, which was then absorbed by the claimant as a matter of German law. I can be quite brief here. I think the tribunal was satisfied that the claimant was an investor and looked towards German law, which held that all of the original investors' rights and obligations were succeeded to by the claimant. There were other interesting jurisdictional issues, most notably the question of temporal jurisdiction arising out of the two successive treaties. The tribunal did not deal with this in the jurisdictional phase. Instead, it dealt with it together with the merits as part of its award. The tribunal's decision on jurisdiction rationale temporis is quite significant, actually, and is often cited in disputes about temporal jurisdiction. Most notably, the Kingdom of Thailand argued that the tribunal had no jurisdiction in respect of disputes that arose before the coming into force of the 2002 treaty, which was October 2004, emphasizing that the 1961 treaty, as we talked about earlier, did not give investors the right to initiate investor-state arbitration and only provided for state-to-state arbitration. The respondent placed emphasis here on the principle of non-retroactivity in Article 28 of the Vienna Convention on the Law of Treaties. The claimant took a different view, arguing that unless expressly stated in the treaty, investment treaties should be assumed to cover pre-existing disputes, citing the Permanent Court of International Justice's decision in the Mavromatas case. And the claimant also argued that even if the tribunal were to adopt a narrower basis for jurisdiction, the fact that there were two successive treaties with similar objects and purposes provides a basis for the temporal jurisdiction of the tribunal. Significantly, the tribunal rejected the defense of jurisdiction rationale temporis, although it did not adopt the legal rule advanced by the claimant. And this is significant. What it held was that the tribunal has no jurisdiction to consider disputes before the 2002 treaty came into force. So disputes before October 2004 fall outside the jurisdiction of the tribunal. The tribunal rejected the claimant's argument that unless a treaty expressly specifies, a tribunal has plenary jurisdiction over disputes arising prior to its coming into force. It distinguished the PCIJ cases relied upon by the claimant. Tribunal also rejected the successive treaties argument because the cases relied upon by the claimant involve successive treaties where the prior treaty provides for recourse against the state, either through domestic courts or investor-state arbitration, and that was not the case here. However, and very importantly, the tribunal drew a distinction between breaches that crystallized before the treaty came into force in October 2004 an ongoing conduct that started before 2004, but which crystallized into a dispute after the treaty came into force. The tribunal held that the latter fell within its temporal jurisdiction, and that is the part of the award that's often cited. So second, the tribunal had to then consider whether the respondent's cumulative conduct over a period of more than 10 years amounted to creeping expropriation of the claimant's rights, while affirming that creeping expropriation is a type of indirect expropriation, comprising a composite series of acts attributable to the state over a period of time that culminates in taking of property. The tribunal did not accept that this was made out on the facts because the claimant's contractual rights were not infringed with or interfered with ultimately, because it still held the rights as a shareholder to the company, even if its profitability might have been diminished. But on the question of the breach of FET, based on the same facts, the tribunal found that Thailand's treatment of the claimant breached the investor's legitimate expectations under the 2002 treaty. First, affirming that legitimate expectations are part of the FET standard, the tribunal then found that the government's assurance of a reasonable rate of return gave rise to legitimate expectations on behalf of the investor, despite there not having been an express guarantee of a particular rate of return in any document. The tribunal was persuaded by the fact that the government and the investor both conducted various studies of the internal rate of return of the project, and the Minister of Finance wrote in a letter to the claimant that certain measures would allow the consortium to achieve a reasonable rate of return on his investment of 14%. The tribunal also had regard to the semi-public nature of the concession, which meant that it was very regulated, and the only mechanism for deriving a return would be contained in the ability of the consortium to charge tolls, which was a decision it could only make in connection with the government. So ultimately, the tribunal found that the Thai government's disregard of requests for toll increases over a period of 10 years, where those toll increases were justified under the contractual framework of the parties' concession agreement, amounted to a breach of FET. Before I conclude, a few final observations on what happened after the award. Obviously, an award is only a piece of paper unless it is complied with or enforced. Following the conclusion of the arbitration, Thai officials criticized the award and refused to pay it. There were then proceedings in the US and Germany seeking to enforce the award. I think two things of note. Thailand sought to challenge the award in September 2011, 2 years after the award was filed. Thailand made the application before Swiss courts based on evidence it allegedly unearthed 2 years after the award regarding a parallel ICC arbitration, which suggested that the bankruptcy administrator had no capacity to pursue the treaty claim. This request was ultimately dismissed by the Swiss Federal Tribunal. Reports suggest that the tribunal ruled that the state must have known about these facts at an earlier stage, and certainly when the annulment window of 90 days was still open, and yet Thailand failed to file a request. The last point of interest is a set of enforcement proceedings in Germany, which resulted in the seizure of the private jet of the former Thai Crown Prince, now the King, when he arrived at the Munich airport in July 2011. The private jet was to be released only in exchange for a bank guarantee amounting to the value of the BIT award. These proceedings started in June 2012. Thailand eventually appealed this to the German Federal Court of Justice, which then remitted the issue back to lower courts because of the issue of sovereign immunity in its view was not properly dealt with. And the lower courts then dealt with the issue in February 2015. And it was thereafter appealed to the Federal Court of Justice in October 2016 when the enforcement against the jet was finally confirmed. So proceedings started in June 2012. After protracted appeals, confirmation of the execution was obtained in October 2016. So as a few final takeaways, the fact that there is no exit convention arbitration means that enforcement takes place under the architecture of the New York Convention and the law of the sea, which gives certain powers to foreign courts to decide matters to do with the enforcement of arbitral awards. It also means that the award debtor, in this case Thailand, has one exclusive means of recourse against the award, which is to challenge it at the seat within the time period applicable under the law of the seat. So it therefore matters what the seat is, and it matters what the time limit for challenging an award will be under the seat. And under the laws of most seats, that time limit, which is also stipulated under Article 34 of the model law, will not be easily relaxed. For example, Singapore courts have categorically ruled that under no circumstances will the 90-day time limit be extended. And what it also means, though, is that each time an award creditor seeks enforcement in a jurisdiction, despite not having set aside the award, the respondent state has an opportunity to raise defenses to enforcement under Article 5 of the New York Convention. And that process can take some time depending on how court processes for enforcement unfold in each jurisdiction. But as the whole episode in Germany shows, enforcement of an investment treaty award under the New York Convention has real teeth. And with that, I will conclude my presentation. Thank you.
Okay, thank you so much, Jonathan, for this very enlightening and very on a very wide coverage on the issue. And you have broadly covered on the Thailand's investment treaties and reported arbitration cases. So from the presentation, it established that Thailand has signed 47 investment agreement treaties, out of which 36 it's bids, four bilateral free trade agreement, 87 is plurilateral trade agreement. And it established that before 1989, there was no ISDS clauses being used in Thailand, and only from 1989, ISDS was additional. It was used as an additional condition on the condition that Thailand will ratify ICSID convention, which is not done so far. And from 1993, there are some form of ISDS provisions. And from the free trade agreement signed between Australia, New Zealand, and Japan and Chile, it is clear that these were signed with the ISDS conditions. And you have also largely covered on the investment treaty cases where Thailand was the respondent, and then on the other side where Thailand also seated as a claimant. And on overall, you have widely covered on the Walter Bowie versus the Kingdom of Thailand, and given the very comprehensive issue on this. And I'm sure that all the participants will have a big takeaway and experience from this and use to the best possible ways and means. So with this, I would like to thank you so much for this hard work. And now we have the last speaker, Napramat. She will do a presentation on Thailand's experience in the investment treaty and Thai government and investors' preparation for defenses and possible claims related to COVID-19 measures. So, Napramat Thamamir Raya Decho she is an experienced litigator with over 20 years experience of trial and appellate advocacy at all levels of the Thai courts. She also has substantial experience with international litigation and international arbitration gained from numerous cases in Singapore, Australia, Cambodia, Myanmar, and Laos. Her general practice covers various industries, including construction, insurance, reinsurance, and telecommunication. Napramat, who is on the panel of arbitrators for Thailand Arbitration Center, currently serves on the Commission on the Arbitration and Competition of International Chambers of Commerce in Thailand and sits as Vice Chair of the Thai branch of the Chartered Institute of Arbitrators. So this is in brief on the introduction of her experience. So with this, I would like to request Ms. Napramat to do the presentation. Thank you.
I will share my slide first. Can you see the slide now?
Yes, yes. Perfect.
Okay.
No problem.
Yeah, okay, thank you. So, good morning and good afternoon, ladies and gentlemen. Thank you very much for the your introduction, Mr. Wang Di. And first of all, I have to thank you, the Thai Arbitration Institute, that invite me to chair this panel with the distinguished speaker. As you can see from the previous presentation that our speakers already almost cover all the issue of the investment arbitration. Sheena and Daniel already present their defense for both investor and the state, how to defend this kind of information considered as a substantive defense for both parties, right? And then you also hear about the what about case, the historical investment arbitration case for Thailand, right? For myself, I'm going to share with you some of the arbitration cases related to the construction dispute, right? This topic actually come to the right time because in the past 3-4 days that the Thai and the English newspapers and the media in Thailand have discussed widely as the hot topic for Thai government order to lock down the construction site in Bangkok and another 10 provinces around Thailand. This lockdown actually specifically for the construction sites for 30 days. Why? Because the new cluster popped up since last April for the COVID-19 cluster in Bangkok. This is kind of a serious thing because why? Since the COVID pandemic took place in the last year, Thailand never locked down. We just have kind of semi-lockdown that you can work from home and you can buy food and from the restaurant. But however, right now the number of the infected people have been increased, jumping from like 10, 20s to now 5,000 daily. That's something cause the concern to Thai government, right? So what happened after the government announced the COVID-19 measures? Yes, the construction community, they say that they have lost almost 140 billion baht for this kind of 1 month lockdown and affected 3 million laborers. And as the construction community claimed that Thailand, the construction sector in Thailand value approximately 8% to 9% of Thailand GDP. So you can see that how the construction sector is really important for Thailand. And actually it's not only for Thailand, for other countries as well, right? So as the question for many people raised, what because the investor who invest in the construction sector in Thailand, how they respond to this, you already have the answer how the investor can pursue the claim against the government for the maybe improperly or the wrongful law and order that issued during the COVID period of time, right? In Thailand, when we talk about the arbitration regarding the construction or the infrastructure project, most of the media use the court for the damages that the government have to award to the investor or to the constructors when the government lost case in the commercial arbitration or in the investment arbitration, they call this kind of remedy that as high cost of stupidity. That is something only used in Thailand. Why they call something like that? Because they think that some of the media think that what is the reason why the government have to sign the investment treaty? It may be the question of the lay people, but as the lawyer or the legal professional, the legal professional can give several reasons why Thai government or other developing countries have to sign this investment treaty. If they already know that there is the ISDS or the requirement that the foreign investor can file the investment arbitration claim against the government directly, because the construction or infrastructure projects require the high investment of technology, expertise, time, and money from the foreign investor, right? The government, the developing countries facing the budget problem, they cannot invest all the money for the toll, the dam, and the power plants by themselves. They need the foreign investor to make this project happen in the country. That is the reason why the government in this developing country, including Thailand, to sign the treaty investment, right? So this is another big project for Thailand in from last year until currently. It seems to be maybe a dream project, who knows? But the Ministry of Transportation in Thailand already confirmed that the government going to do the land bridge in order to facilitate the cargo transport between the Gulf of Thailand to the Andaman Sea. You know, this project actually replaces the Thai Canal or Kra Canal. That it is, I can say that more than 200 years dream, because it's probably the plan before the Suez Canal. But right now, the Thai government considering to do this. So this I don't know whether or not this can be the investment arbitration in the future, but I hope not. Okay. And there are several Thailand mega project infrastructure in 2000 in this year. This project, Eastern Economic Corridor or EEC, actually took place before COVID period, but right now it seems to be stopped and have the not yet stop but slowing move, because I think that the travel restriction and the other foreign investor also want to invest their money in their own country, like Japan or China. So then I think that Thai government will have to look back how to do or how to revise the plan for this kind of mega project, right? Regarding the investment treaty in Thailand, Jonathan already gave you the big overview. Actually, seen from the history of the investment treaties, I have to thank for the detailed information, Jonathan. You work really hard in this detail. So I'm not going to talk about it. Okay, I just only show this slide for something that probably some of the Thai audience look over why Thai government had to sign the treaty, the investment treaty. For the, I use the example of Thailand-Australia FTA, because why? Because currently we have our country been sued by Kingsgate, the Australian investor, right? So when the government had been sued, the media look over the interest that Thai government already obtained from this FTA, but the media only target how much Thai government have to pay for the legal fee, right? And whether or not Thailand will be lost in this investment arbitration and have to pay the exorbitant claim to the King's Gate, right? If you can see from this summary of the interest and benefit that Thailand signed with the Australia, we already obtained several things from this FTA, right? So we allow several Australian investors to access to Thai market, how much money that they put in Thailand. That's something that maybe not only Thailand, but other countries will have to consider. Okay, then I go to talk to another historical case is the Hopewell saga. Why is saga? Because this case took almost actually 30 years, but not yet finished. What happened for this case? This case actually, I think is the case took place after the waterbound dispute. When Jonathan talked about the waterbound is the tollway next to the Don Mueang Airport. But the Hopewell is also next to the waterbound tollway. Hopewell is actually the Hong Kong investor that established the Hopewell Thailand in Thailand in order to obtain the construction project in Bangkok. It's only 60 kilometers tollway from Bangkok to outside Bangkok to Ayutthaya, right? 60 kilometers. What happened? Hopewell proceeds this as the lead constructor, right? But it's take like the project commenced from 1990 and been terminated by Thai government in 1998, 8 years. But the progress of the project complete only 14%. That's why Thai government terminated the contract. The problem for this case is not because Hopewell. Some of the part is fault by the Thai government because the Thai government cannot allows the access to the constructor, because the government have to sue people and evacuate people from that area. That's the big problem. They cannot do it quickly, and is part almost for government administrations for these kind of cases. And then what happened? Hopewell pursue at that time, yet even though there is already investment application, however, at that time, Thailand and Hong Kong didn't have the treaty together. That would be another reason why Hopewell pursued the commercial arbitration case in Thailand, and they won partially award from the commercial arbitration. But you can see that terminated in 1998, and Hopewell pursued the case in 2004, right? So after obtaining the award, what happened? The Hopewell and the claimant have to file the enforcement of the arbitral award in Thai court. We call the administrative court. And for the first lower court, the court dismissed because the court dismissed and not enforce the award because the court give the reason that the claimant submit the claim over the time or time bar. So then Hopewell appeal to the Supreme Administrative Court, and then the Supreme Administrative Court believe that what Hopewell made the submission within the time bar, and then allow that the state of the government have to pay the have to make the payment for the compensation to Hopewell. It's not finished like that. Actually, it should be done, and then government have to make the payment. However, the government tried to pursue another court, we call the Constitutional Court, saying that the order or the judgment of the Supreme Administrative Court is contrary to the constitution law of Thailand, because the order that make and confirm the submission within the time bar is contrary to constitution law. So you can see that 30 years, nothing, right? So maybe this is something the foreign investor may be consider that, okay, they may consider investment arbitration instead of commercial arbitration, but they have to consider first whether or not that dispute is under the jurisdiction of the tribunal, whether or not their own country already signed the investment treaty with Thailand. That's something that they have to consider. So I go to the takeaway point that in case, because in many investment arbitration, many people say that the claimant and the foreign investor would be much more advantage than the government. Why? Why? Because the government is too big, and the nature of the case involving public policy, several ministries, several departments, officials. Sometimes when Thailand obtained the notice of arbitration, what happened? No one knows who would be responsible to reply. That's something is, I think not only Thailand, other country would be the problem when the lawyer asks when the lawyer have to represent the state, right? And also, if you represent the state, something you may be get a lot of pressure because high scrutiny by press, by authorities, by NGOs, right? And the state as the respondent also facing the exorbitant claims. Sometimes, as Daniel said, that the claim is even higher than like the budget or the GDP of the country or the currency reserve of that respondent state. You know, I think that it makes a lot of pressure. Any government that have to handle this investment arbitration will have to think a lot whether or not try to delay the case. That is not a good option, or try to mediate. That may be another good consideration. And again, the different interest between the investor and the state in pursuing the investment arbitration quite different. The investor, they have very clear interest that they want to make the pressure against the government. They want to make the noise to the international business community, right? But the state have to protect the public policy, have to protect the public interest. That's something quite different. And when the state want to make the argument, the state have to think a lot. How? Because the state argument can be impact to other foreign investment as well, right? So that's something that state have to be very careful in handling, make the argument against the foreign investor. And again, I work sometimes with the government officials or the ministry. So sometimes we know that when we have to represent the state, what the problem is that since the bureaucratic system caused the problem, the document production, the witness seem to be difficult to find, or even you have a lot of documents. The systematic to keep or retain that document is maybe not in the single unit like in the company. It's easier, right? So maybe my suggestion that the state as the respondent have to make the guideline how to respond with the investment arbitration. And if the state wish to have the list of the consultant, they can create their own investment arbitration powerhouse, right? Have their team to follow the trends of the investment arbitration, the arbitral awards. So that sometimes would give the benefit for the state to have more information and to react to the investment arbitration claims in time. So that's something I like to share for today. And thank you for our distinguished speakers today that come to join and exchange very useful and helpful information, not only Thailand and for other countries as well. Thank you very much.
Okay, no Pramad, thank you so much for this very comprehensive presentation, and whereby you have broadly covered on Thailand's latest announcement of COVID-19 measures, where government has announced 30 days temporary lockdown of all construction sites, which is estimated to cost 140 billion baht and affecting around 3 million laborers. He also raised on issue on how the state will be protected of taking measures in response to emergency of COVID-19 pandemic, and how will the investor be indemnified if they have incurred any substantial loss. And the other thing which you covered is the nature of construction projects and its relationship with the host state policies, the implications. They have also broadly covered on the recent initiatives taken by the government, especially when you covered on the Southern Land Bridge issue. And we have also given the very comprehensive on the examples of investment and treaties signed by Thailand, and focusing on TAFTA, that is BIT, and CPTPP, that is MIT, which is not yet been signed by Thailand. And you have also cited on the regional trade agreements. And you have also broadly covered on the Thailand-Australian Free Trade Agreement, which is signed on 1st July 2005, that how good it was to take advantage of such good things. And lastly, you have explained in detail about the case between Hopewell and the State Railway of Thailand. And from there, you are trying to explain that how should we take actions and how it will have implications here and there, and to take experiences out of this to use for the future course of action. So with this, I would like to thank you so much for this very enlightening presentation on the issue matter. I'm sorry that we have taken some extra time, but nevertheless, I think since the issue is very important, not only for Thailand, but I think we can see here there are many participants, it is over 52 participants. I think it must be more than 60 now. So that's where, because people feel that's very important, that's why there are around 80, 90 countries participating on this webinar. Because some of them may be still lying idle, not knowing what to do on this issue, and some of the problems might be already on the issues, and some of the problems might come up. More problems might come up. So in Thailand, we have many foreigners who has made investment. And then also we have many Thai citizens who has also invested so much of money in other countries. So it's going to help them so much on this issue. And that's where the main objective of this webinar is to give them some ideas, resolutions, way forward on this by taking the huge, the advantage of this time-tested experience by our speakers. So with this, I would like to now give this forum to the participants. If they have any questions, queries, or comments, anything that they want to share here or take away from this webinar. So now the forum is open for question and answers. You can even write down your questions on the chat box, or you can simply ask question, and you can also specify that to whom you want to raise a question or whatever it may be. So the floor is open for the participants now. So anyone? So any question from anybody, because I know that there are many participants and they really want to raise questions. That's why they have all come to listen to this webinar. So if you have any, do let us know at the earliest so that our speakers are ready to explain or clarify anything on the issue. If there is no one raising any question, I would like to ask one particular question to China for the advantage of the participants. Just wanted to know the difference between, the basic difference between investment arbitration and commercial arbitration, because I know that most of the participants are not lawyers in this forum, and the introduction may be needed on this so that they may be familiar with the commercial arbitration, I know, but I think some of them may not be knowing on this investment arbitration. So if you can give basic difference on these two, and at this period of time, what would be the advantage on their side to use these tools, either of these two, which would be better?
Well, they're actually quite similar in terms of the practicality. So in commercial arbitration, it's based on the arbitration agreement and the contract. In investment arbitration, it's based on basically the dispute agreement in the BIT. You look at the terms of the commercial contract, or you look at the terms of the BIT to determine what possible claims and breaches are. In terms of the actual mechanics, it's quite similar. So you would appoint normally a three-person arbitral tribunal. You have several exchanges of written pleadings, then a hearing, and then the award. The process to start investment arbitration is a little bit different, and you have to look at the requirements under the particular BIT. There's normally a requirement for what's called a trigger letter, which is basically a notice of dispute. And then I think the main difference there is then you have what's called a cooling off period. So it's like a mandatory period to try mediation or negotiation before you can go forward with the investment arbitration, which isn't something that's always included in arbitration agreements in commercial contracts. In terms of the advantages, I mean, it would really depend on what the events giving rise to the loss are. I think a contractor that's looking at their options needs to really carefully think about what the facts are and what the losses were incurred, and if it is fits better as a breach of contract or a breach of the provisions of a BIT.
Thank you so much. I think I asked this question because as I have made it very clear that some may not be lawyer or not used on this, but they must be a business entity or business individual. So if we explain on this, then they will know where to go, how to do it. Thank you so much, China, for this clarification. And since no one is asking a question, I would also like to request Daniel to give some explanation on this, to know that how could the government infrastructure project be affected by the investment arbitration? Because if the government is also party to the project, they could be also affected. Because supposing the work has been suspended, case is going on, and that work, which is actually a part of the government, so how will that be compensated or recouped later? So just wanted to know that how it will also affect the government, the infrastructure ultimately when there is a case.
Well, it depends when the claim is brought, and sometimes the claim isn't brought till a fairly advanced stage in the project when it's nearly finished. Sometimes it's brought at a very, very early stage before any substantial work has even started, because the investor feels that the basis for continuing the project has been removed. The carpet has been pulled from under its feet. I think the best way for a government to affect the infrastructure project is to ensure that the investor can carry on business in a good and secure environment. I think that all parties also have some interest, even if there are disputes, and we see this in commercial cases as much as anything else, in continuing work as far as possible, even where there is a dispute. Half a building is worthless. In fact, sometimes it's less than worthless. It's very bad. So one must press on.
Thank you so much, Daniel. Because I was concerned because sometimes when there is a case, sometimes case goes for like 30 years or 15 years or whatever, like 5 years. But ultimately the structure, which is, if that work has been suspended, then I think we should be also aware of the implication of the property which is in issue. If there is no progress, if nothing has been done, that's going to ruin, and that will be also extra cost. So for this, I've raised this, and I hope that this would have helped all our participants on knowing that how to take actions and to be aware of the consequences of taking the cases. Thank you so much, Daniel. Then I would also like to request Jonathan to just give some explanation on that. I just wanted to know that will it be justifiable for the host state in passing laws to stabilize the economic crisis, which affects the foreign investors negatively? So for the government, it has no choice but to pass the law, because without law, that people don't listen. So law has become inevitable. They pass the law at least to save the country. So, but will that be a justification as a means of defense against the investor who has been negatively affected by this law? So just for the advantage of the participants to know on this.
Yes, thank you, Mr. Wangdi. I think the short answer to the question is yes. The government's valid reasons for passing a law are relevant both to the question of whether there has been a breach of its obligations. For example, tribunals increasingly take into account whether the government has exercised its right to regulate in considering whether there's been a breach of the FET provisions of a treaty, or in deciding whether there has been expropriation. So that's one way in which it can become relevant. Alternatively, even if there is a breach of a treaty, those reasons that you raised, Mr. Wangdi, can become relevant also as defenses in the many ways that Daniel has outlined in his presentation. For example, if it's possible to argue that the measures were necessary, I think you could both argue that excuses, that is not a breach of the treaty, but also that it excuses the government from any responsibility under international law.
Thank you so much, Jonathan, because you can still see there are some participants still there. they're eagerly waiting to take away some from our this webinar. So that's why I'm just, if they are not raising, I'm just trying to raise some question on their behalf. And I would also like to request Ms. Napramat to just briefly explain on since you have covered on these COVID issues, what would be the foreseeable claims by foreign investors in the post-COVID-19 pandemic? So what are the likelihoods of like claims which the investors might make against the host state?
Okay, it's just in my mind. So I think that maybe the foreign investor may claim that the COVID-19 measures is not appropriate measure. That caused some of the problem to the investor. For example, like the order, the 26 June order that for the lockdown, 30-day lockdowns for this construction site. They may claim that actually the government can choose to do other things, not to close down this all construction site in Bangkok, because maybe they can show the evidence that probably the problem is not at the construction site, but the problem is caused from the illegal immigration, right? Because that is something that government have to target, not target the construction site, but the government have to target how there are so many illegal laborers from our neighbor countries come across to Thailand and also infected. That is the reason. The measures not justifies the objective that the government want to cope with the COVID-19, something like that. So that would be something that would be the foreseeable claim that made by the foreign investor. So that is my answer. Thank you.
Okay, thank you so much. And with this, I think we have taken more time, means that there is more concern on this. That's why I think when things are very important, we need to take time, because without taking time, I think people will not be able to understand this, because this is a very complex issue. And you know that once we are in a problem, it takes ages to resolve this matter. So for that reason, we have organized this webinar to get experience and to get knowledge from you all, because you have been working on this for ages and ages, and you have all this time-tested experiences with you all. So sharing your experience will be a great benefit for Thailand and all people living in Thailand and Thai people who are living in abroad where they have spent money and all. So since this is a very big subject, it's quite difficult to cover up within 1.5 hours. But anyway, this is an eye-opening sort of experience for us. And if needed be, if there is a request, then I think we can also organize a subsequent webinar based on this topic, and where we will focus only on one point, so that we don't get carried away with many issues. Focus on one point, and we can also have a series of webinars on each topic based on that. So this will really benefit us. And I, on behalf of Thai Arbitration Institute, and on my own behalf, and also on behalf of Tiliki and Gibbons, would like to, from my heart, really would like to thank you all so much. We have not given you enough time to do the preparation, but you have done a marvelous job in doing this presentation. It's a really eye-opening experience for us, and for all the participants, I'm sure that it has really benefited them. And then not only, as you all said, that once the COVID-19 has subsided, then you can also make trip to Bangkok. In fact, trip to Bangkok and enjoy a holiday, have a meeting, webinar, seminar and all. We can do many things in the subsequent, so that once we see face to face, many things can be resolved easily. So looking forward to see you all again and again. We will keep in touch. This is just a beginning. So more things are going to happen. We want to extract as much as possible from you all for the benefit of the larger society of the world. So I wish you all best of luck in your profession, wherever you are, so that you'll make great impact to the society of the world. So far you have been contributing so much to the world. So from here again, I and my institute, we would like to again wish you all to be successful in all your profession. All 4 speakers, I would again like to thank you again. So I will see you when I see you next time in next webinar, if possible. Thank you so much. Bye-bye.
Bye-bye.
Thank you so
Thank
much.
you very
for
much.
taking
And please
time.
call on us in Geneva. We'd be delighted to
Yes.
see you.
Yes, we'll do that. We'll keep in touch. Thank you so
Definitely.
much, everybody. Bye-bye.
Bye.
Bye.
Thank you. It was a pleasure. Bye.